Look, when we laid the complaint at the start and I wrote to the public protector, we'd hoped that an investigation was taking place. We were satisfied with the first step, which is what the public protector did, because you must oppose corruption. What was most disappointing is the fact that despite all of these pronouncements, which were made in the judgment by the president to say he wants to institute a commission of inquiry, he's used every legal process to try and obfuscate the matter. So it's good that a cost order was given against him. But I thought what was also profound today is the assertion we've always held, is that the ANC has protected the president and the president has failed to lead. I will say that publicly because it's clear Jacob Zuma has never been interested in investigating state of capture allegations, regardless of how they were laid, who it came from. It should not be a remedial action that a head of government must investigate impropriety that is said against him. He should, if he's a decent leader, a person committed to the values of the Constitution, be the first to take action. Jacob Zuma failed on that account, and clearly his party acted to protect him in this regard. And therefore, ultimately now the judgment lays out a timeline which is appropriate to say within 30 days such actions must take place. And we hope to get to the bottom of this so that wherever the Gupta family, the presidency, Tutuzane has been involved, that entire investigation takes place. It would be important for South Africa and the resources of the people of this country that we get to the bottom of this issue so we can free up those resources to provide services to our people who desperately need them.
There's a very real possibility that he appeals. Will you seek an enforcement order if that happens?
Absolutely, because what is absolutely crucial now is that if he does appeal, I would doubt that another court would not be consistent in keeping to the cost order. So it ought to be to his personal cost in this instance. And so him and the Guptas, if they want to continue this racketeering business, they must then fund that legal case. But more seriously, we would oppose that application because we believe that we've delayed this matter for long enough. It's been ongoing for months on end. And now the people of South Africa need to know the truth. We can't be spending weekends reading in newspapers about this allegation, these Gupta emails. And it goes further. The ANC collectively can't sit by and allow this matter to simply drag on. It is now time that we set Jacob Zuma aside, we rid South Africa of corruption and move on to ensuring that we get a clean government that will ensure it delivers services to people.
The implications of a court within a very short space of time, twice saying that the president is unfit to meet constitutional obligations. What are the implications of that for the ANC?
Well, they're crucial because when we moved a motion of no confidence in Parliament, it was then that the ANC should have known that in fact Jacob Zuma is unfit to lead. And that's why the Constitution gives that provision. And they failed to exercise their duty there. What is beginning to show is the fact that the courts are speaking the rationality that as opposition parties we've certainly been speaking, to say this president is unfit to lead, that the ANC is protecting this president, and that it's time now as South Africans we take that power into our hands. So I want to congratulate the judiciary and applaud the very principle that says the judiciary should remain independent in South Africa, that as I maintained before, that principle, that the judiciary should be able to give laws that guide and give clarity in the Constitution so that institutions of government, the public protector, the judiciary, are upheld so that we can continue to fight against the thuggery that is supported by Jacob Zuma and protected by the ANC.
Anyway, all said and done, we welcome the judgment by the court and it indicates the demand that the EFF has made in Parliament. Mr. Zuma should never address the Parliament. It's not honorable. Come 2018 State of the Nation address, hopefully the Nazareth conference of the ruling party will take a resolution that he should actually come closer to the Parliament and address Parliament.
And if he attempts an appeal, I mean, what's the action there?
Well, we look forward to a situation whereby he does not do so, because he will be actually making his case far more worse, because there is an impeachment case that should be actually an order be made by the Constitutional Court very soon, and it will add to the legal woes of the president. The earlier he steps aside, the better for the country.
He's been found to be conflicted on 2 occasions in less than a week in the NPA matter, and now even here the judge said he's conflicted and has direct interest in the outcome of the inquiry into state capture. What do you make of that?
Well, we have always said as the economic freedom fighters that Mr. Zuma is a constitutional delinquent, and this time it has proven that he's not only a constitutional delinquent, but a gross constitutional delinquent of objectionable conduct and character and couldn't enhance the court's identity, personal cost against him.
Mr. Gardee, we're talking amounts of millions here that he will have to repay. Where do you think he will find the money?
Definitely, the vendor building society will not be able to afford him that money. We will have to attach the Nkandla homestead and see how far it goes to the auction.
Thank you. Thank you. Mr. Lekota, I mean, what do you make of this extraordinary ruling? It's the most damning ruling that we've seen against the president in his long and colourful history of litigation.
Well, we do not think that it's extraordinary, because right from immediately after Mpapologwane, we pointed out that we couldn't continue to follow leadership of a man who said the ANC is above the Constitution. Once you took that route, you were going to end up here, because this man has been acting as law unto himself, and the ANC has been comfortable. In fact, the blame for this situation must be squarely placed before the entire leadership of the ANC, both for the first 5 years and the second 5 years, that they have protected him. They themselves have failed to uphold the Constitution. And that was confirmed by the Constitutional Court in the Nkandla matter. Because now when the party that he is leading, well, I can understand his case, he can't read, but you can't tell me that the entire ANC caucus cannot read. It cannot read that this Constitution is the supreme law of the land, that you can't do anything contrary to what it says. They did that. They allowed him to do it. They protected him when he acted against the Constitution. They are still doing that. Now, the court has done an important departure this time, because it's now saying, Mr. Zuma, you now pay out of your pocket. Thank you. One of the things that this thing of the ANC believing that it is above the Constitution is that they think they can allow him and themselves to do as they please with the taxpayers' money. For the first time now, the court is going direct to the issue and saying, you who have done this act, pay out of your pocket. It's important because it's going to protect ordinary citizens from the abuse of the tax that we are paying year in, year out.
We saw this extraordinary kind of level of comments that were delivered in the wake of the Nkosana ruling from, amongst other people, Minister Batabile Dlamini, in which he said that this very same judge who read out the rulings today, he and his fellow judges had been told what to say in that decision. I mean, I think you and I would probably both agree that the strength of this decision is probably going to be met with quite a political reaction. I mean, how do we ensure that the judges are rightly and fairly criticized, but not attacked with allegations of corruption?
No,
And just to add to that,
before, please, let me just deal with this. Before anything else, we have to observe, as we stand here, that the ANC has allowed the president to take the executive of our country to break its oath of office. Then they brought the judgment of Nkandla into the National Assembly, into the legislature. And in the process of that Nkandla thing, now made the legislature break its oath of office, as the court found, in the Constitutional Court found. They are now trying to find a way to weaken the only remaining leg of state, the judiciary. They are trying to find a way to weaken it, to render it weak and pliable. The judge dealt here with the provisions of the Constitution, the powers of the public protector. We, the opposition parties, have never been able to amend the powers of the public protector. All we have done has been to come to the judiciary and say, beyond this point, we can do nothing. Please help us interpret the law. And all that the judiciary has done has been to interpret the law. The individuals who who are making these wild statements about the judiciary and so on the streets, in their meetings and all of that, need to be arrested and brought to the courts. Because anybody who undermines our judiciary needs to be made to confront the consequences of their agitation without any foundation. If you want to attack the judges, give us your grounds. If you don't, we must lock you up so that you know that that is not something to play with.
All right, SABC,